Kumar, student of 5th year BLLB, on behalf of CMI University School of Legal Studies, extend a hearty welcome to our esteemed guests who have joined us today for the guest lecture on the developing concepts and trends of arbitration in India. We have with us today, Sir, Mr. M. Brungesh, Director, Arbitration and Conciliation Center, who have consented to deliver this guest lecture. Sir had completed his primary education in T. Narasipura and his LLB at JSS Law College, Mysuru. Till then, later, joined the chambers of T.V. Krishnarao. In the year of 1992, Sir established his own office and practiced as an advocate in Mysuru till the period of 1998. Sir also appeared for judiciary and became a judge on 2nd of March 1998. Sir is currently the director of the Arbitration and Conciliation Center at Bengaluru. We welcome you, sir. We are also accompanied by our beloved Dean, Director, Sir Ravi Kumar, Deputy Director of Judicial Academy, Faculty Coordinators and Student Coordinators of Center of Alternative Dispute Resolution and the participants. As Resident Content said, and I quote, "At all events, arbitration is more rational, just and human than the resort to the sword." With that note, I would like to call upon Deepika from 6th semester LLB to render an invocation song and commence the ceremony.
Smarami Mahaganapatim Manasa Smarami Mahaganapatim Manasa Smarami Vashishtavamati Vandita Mahaganapatim Mahadeva Sutam Mahadeva Sutam
Thank you, Deepika, for blessing the event with your soulful voice. May I request the Dean's Professor, Dr. T.R. Subramanian, sir, to deliver the welcome address.
Very good morning to all of you present here. On behalf of the CMR group of institutions and on behalf of the chairman and on behalf of the CMR School of Legal Studies, I deem it a great privilege to welcome Brungesh, the present director of Arbitration, the Center for Arbitration and Conciliation. He is a person with immense experience and he has been serving as a district judge in several districts, including Markara and other places. And his immense experience in running the state arbitration center and conciliation will help especially the students of law who are in studying the institutions of arbitration as well as conciliation. Without just wasting our time, I request the Honorable Sir to speak a few words for about an hour or so on the institutions of arbitration and conciliation.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. They should be reciprocate. You should reciprocate. Whenever somebody says namaskara, It's our culture that we should reciprocate. Namaskaraಗಳು. Wonderful experience and wonderful response. I'm happy. And before starting today's, the lecture, not audible. No. Before starting the discussion on this wonderful concept of Arbitration and Conciliation Act, first of all, I would like to thank the organizers of this class, Sri Subramaniam sir and his team, for giving me this wonderful opportunity to share my a little knowledge about this Arbitration and Conciliation Act. With this prelude, let me start share my a little knowledge with all my young friends, because you are the future generation of this country. And of course, what is arbitration? What is conciliation? Somebody says that this is new trend, a new topic. So many things they say. But I say that it is not new to our country. Because in Ramayana, we see the instance of Angada visiting Ravana's court and trying to conciliate and trying to convince Ravana to release Sita Mata. That the first ever instance we get to see about something about this arbitration and conciliation. The second instance, the mythological background or mythological instance where we get to see is in Mahabharata. Before Kurukshetra war, it results in resounding. So in Mahabharata, so before the commencement of this Kurukshetra war, Krishna visited Duryodhana and others and made an attempt to convince them to give the offer of the empire to the Pandavas. So this is the history and background we have as far as this arbitration, concept of arbitration and conciliation is concerned. So now, but the title of the concept about which I am supposed to speak is Developing Concepts and Trends of Arbitration in India. So therefore, if I only focus on the mythological instances, I am sure you younger people will not like me, of course, like my lecture. Therefore, I must speak something about the modern trend and concepts which are incorporated by passage of time in the Arbitration and Conciliation Act. Though I brought to your notice two instances which are mythological, but the history speaks that virtually this concept started or commenced in the year 1940, Arbitration and Conciliation Act 1940, and of course after 25-26 years the legislators thought that the concepts or the provisions of 1940 Act were not did not suit our conditions, did not suit our societal conditions. Therefore, they introduced the Arbitration and Conciliation Act 1996. So after 26 long years, and by passage of time, I repeat with great emphasis, I say, by passage of time, once what was considered as sufficient to cater the needs of our people, our needs. Later, the legislatures felt that even the provisions incorporated or available in the 1996 enactment were not sufficient to catch the needs of all our requirements. Therefore, in the year 2011, then subsequently in the year 2015, and even subsequently in the year 2019, some many changes were amendments were introduced to this Arbitration and Conciliation Act 1996. Though capture is not changed, but the new concepts are introduced. Of course, if I commit any mistake, I request my brother Sri Ravi Kumar to correct me. Okay. Then next is, what is arbitration? It is a method of resolving disputes between two parties outside the courts of law. Even in many movies and in TV serials, you must have seen so many courtroom scenes. How the unfortunate part is everywhere the judge is projected as a unwanted fellow because he always sits in this way and he doesn't say anything. And even my wife and my parents are under that impression. Even today, we will go to the corrupt remark my wife always passes. Of course, my brother also agree with me. And virtually being judges we do more work than the lawyers. And with great emphasis, with proud, I say that we turn out more works than any other employees of any other departments of the government. But unfortunate part is we are not supposed to speak, and we are not provided with this arbitration and conciliation methods. Wherever we go, we have to maintain silence, absolute silence like an accused person. And if somebody hears some allegation against us, we have to swallow bitter instances. That's why many a time the belly of judges are very always protruding because always we swallow many bitter instances. So this is the tragic part of life of a judge. But let us not go you officers, okay, you young generation. Okay, so anyway, what I said is arbitration is a method of resolving the disputes between two parties outside the courts of law. So what was the scenario then? Earlier, what was the scenario? As I brought to your notice, even in civil movies and TV serials, you must have seen the court scenes where it is always in a closed room or court hall. So the proceedings of the court will take place. Judge sits on a dais, which is slightly almost 2.5 or 3 feet above the ground level of that room, and he sits in the elevated place, and next to him the typewriter, and next to him somebody is typing. So this is the normal scenario you get to see. The bench clerk will be sitting in front of the judge. So this is the court hall scenario. But here in arbitration, though they are also judges, not only judges I say, strictly it is not a court hall. Even any premises which suits the condition, which suits the situation, can be used as a court hall or arbitration hall. So this is number one. Next one is why there must be arbitration. So the normal scenario is in Canada, of course, as a judge, I'm supposed to refrain from passing these remarks. But the circumstances demanding me, therefore I said, my brother also agree with me. ಒಂದು ಕನ್ನಡದಲ್ಲಿ there is a adage, ಒಂದು ನಾಣ್ಣುಡಿ ಇದೆ. ಕೋರ್ಟಿಗೆ ಹೋದವರು ಗೆದ್ದವರು ಸೋತವರು ಸತ್ರು ಅಂತ. Of course, it was the scenario prevailing earlier, not nowadays. Anyway, that is the adage. ನಾಣ್ಣುಡಿ ಎಲ್ಲ ಕಡೆ ಇದೆ. ಗೆದ್ದವರು ಸೋತವರು ಸತ್ತ ಅಂತ. So why it is said so? Because the longevity or the time span consumed for disposal of a civil matter normally would be very long in a regular civil court. But here in arbitration, the advantage is if it's time frame, it is to be disposed of within 1 year, and if it is not possible, then they have to approach the court concerned, and they must extend the time by another 6 months. And if that within that 1 year plus 6 months, if the proceedings is not completed, if the award is not passed, then there is a provision for the court to terminate the very arbitration proceedings, tribunal itself. So therefore, even on the head of the arbitrator, a Damocles sword always hanging. Therefore, he shows all the eagerness to dispose of the matter. But when it comes to regular court, because of the work pressure, you may not believe from 2009 to 2013, for 4 long years, I was the officer of 16 ACM, Additional City Metropolitan Magistrate Court. I was there for 4 years. Do you know what was the pendency there? Pendency of the court. Can you make a guess? Any of you can make yes. Am I audible? Okay. Have you heard me? So please reply. If you don't reply, then it is difficult for me to continue. Then I start doubting myself. Am I reaching? Am I not reaching? That's the real genuine question I get. Could you make a guess? What was the pendency of that case? That court? 18,000. 18,000. From Bengaluru, I was transferred to Chamarajanagar. Of course, there we were together, myself and my brother Sri Ravi Kumar. There the pendency of cases pending adjudication in the entire district was 12,500. ಇಡೀ ಜಿಲ್ಲೆಯಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಕೇಸಸ್ 12,500, ಬಟ್ ಇನ್ ಒಂದು ಕೋರ್ಟಲ್ಲಿ 18,500 ಇತ್ತು. So this is the work pressure I had. Of course, it was the scenario of my court only. It was the scenario of almost all the courts. Then affiliated in Bengaluru city, mostly these criminal courts. So now tell me, when your judge is working in such pressurous condition, can we expect him to be vigilant always? And can we expect him to dispose of the matter within the time frame fixed by the legislatures? Though I am so interested or eager to dispose of a matter, but because of this pendency of other matters and pressure of work, I may lose my concentration. Because judges are also human beings, they are not from heaven. Alva, ನಾವು ನಿಮ್ಮಿಂದಲೇ ಸಮಾಜದಿಂದಲೇ ಬಂದ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಕಟ್ಟೆ. So ಹಾಗಾಗಿ the time span of a civil litigation, why civil litigation, even for the criminal litigation also, was very heavy because of so many factors. Therefore, the legislatures had an idea to introduce this Arbitration Act. That was the first reason. So here, as I brought to your notice, initially 1 year is the minimum time, and if such exigencies arise, then it could be extended. The time frame could be extended by another 6 months. And if the arbitrator, the judge who is called upon to decide the case, does not dispose of the matter within that 1 year plus 6 months, then the entire proceedings will be terminated by the court concerned. So therefore, because of this threat or compulsion, he will do his job as expected by the law. And moreover, another important we have in arbitration is this. I brought to your notice that when I was the officer of 16 KCM, the pendency was 18,000, little more than 18,000. But here, in Arbitration Center Bengaluru, we have our own rules. Arbitration and Conciliation Center rules we have. Rule 32 fixes or mandates that more than 6 cases, I repeat, more than 6 cases should not be given to a particular arbitrator. Normally, this is normal rule. Of course, wherever we go, we come across exceptions. I don't say because as far as one arbitrator is concerned, there are 62 connected matters, and all the 62 matters are given to one arbitrator. This is only one example. This is only an exception. But normally we don't allot more than 6 or 7 matters to a particular arbitrator. Therefore, he will have all the time in the world at his disposal, and he can focus, he can read the papers well, and concentrate and see the position of law, and dispose of the matter within the time frame fixed by the registration. This is the added advantage what we have in arbitration. Okay. And next important, what is that concept or trend in arbitration? What is the caption? Am I right? Developing concepts and trends of arbitration in India. Another concept, important concept is this. Under Civil Procedure Code, the section 15 to 20, Haganayidharinda equal. Section 15 to 20, they speak of place of suing. ಯಾವ ಊರಿನಲ್ಲಿ ಪ್ರಕರಣ ಹಾಕಬೇಕು, ದಾವ ಹಾಕಬೇಕು ಅಲ್ವಾ? ಸೊ ರೆಸ್ಪಾನ್ಸ್ ಇಲ್ಲ ಅದೇ ಕಟ್ಟ. ಈ ಕಡೆ ತಿಳ್ಕೊತೀನಿ ನಾನು, ಚೀಟಿ ಬಿಡ್ತೀರಾ? ರಾಕೆಟ್ ಎಲ್ಲ ಬಿಡ್ತಾರೆ, ಬಿಡಲ್ಲ, ಒಳ್ಳೆ ಹುಡುಗರ. Okay, as per section 15 to 20 of Code of Civil Procedure, the place of suing will be decided. What section 15 says? All civil matters subject to the pecuniary jurisdiction should be filed before the court of lowest cadre. Am I right, sir? Competent to try it. Lowest cadre. So that is the first step of the structure. Second one is whenever the subject matter is immovable property, then the petition or the suit is to be filed in the place within in the court within whose jurisdiction the property is situated. That is the second condition. Normally, this situation arises in case of partition. Suppose there are 5, 6 number of properties are involved in a suit, and one property is situated in Bengaluru, another is in Ramanagaram, and another property is in Mysore, something like that. So then, does the law expect that man to go keep on filing one suit here, another suit in Ramanagaram, and another suit in Mysore? No, it says it's as simple as this. It is an option or the choice is given to the plaintiff. I mean, the person who is intending to file that suit or civil litigation to opt either Bengaluru or Mysore or Ramanagaram. Such choice is given, that is incorporated in the form of section 17. And section 19, compensation. Of course, after the introduction of Motor Vehicles Act, I think section 19 has lost its importance. Let me not discuss much on section 19. And section 20 deals with other instances, other suits, where no immovable property is involved, but only some other rights are involved. I paid some amount to some XYZ, he does not repay, and now I want to recover my suit, and I approach a lawyer, and my first question to the lawyer would be, of course, in near future you all will be facing the same question. Will I get money back? Will I get money back? Now, yes, you will get back. You will get your money back, no problem. So, jurisdiction. So, in case of money recovery and other suits, where the cause of action, there are 4 or 5 options are given. Am I right? 4 or 5 options are given, where the entire cause of action has arisen. That would be the first phase of suing, where the part of what the cause of action has arisen, that also could become the place of suing, where the defendant is residing or where the defendant is carrying on his business. 4 or 5 places could become the place of trial, place of suing. But luckily, the place of residence of plaintiff does not become the place of suing. That is the beauty of section 20. So this is applicable to common civil courts or common civil litigation. So now, in arbitration, the question would be, the arbitration, are we expected to follow the same rigor? I repeat, in arbitration, Are we supposed to follow the same rigor, or is there any exception? Is there any exception for the rule? So this is the question. If you read section 20, if you read section 20 of this Arbitration and Conciliation Act 1996, we get to see or we get to know that an option is given to the parties. An option is given to the parties. What is the option? Let's assume a property is situated in Shivamogga. Why should I take Shivamogga? Let me take my place as my example. Mysuru, Nannuralli ಇದೆ ಒಂದು ಆಸ್ತಿ. An agreement to sell has been entered into in respect of that property which is situated in Mysuru between Mr. A and Mr. B. Incidentally or accidentally, I don't know. Let us assume both Mr. A and B are residing in Bengaluru only. Property is situated in Mysuru. But now, by agreement, the parties can say, let our problem get decided, let us get our dispute resolved in Bengaluru. Under normal circumstances, if we go by the rules of Code of Civil Procedure, it is totally prohibited. No question of permission, we giving permission, because it is the fundamentals or rudiments of law that the parties by agreement cannot confer a jurisdiction on the court. In the same fashion, by agreement, the parties cannot divest the court with its jurisdiction if the court otherwise owns that jurisdiction. This is the basic rudiment of law. ನಾವಿಬ್ರು ಒಪ್ಪಂದ ಮಾಡಿಕೊಂಡು ನಾನು ರವಿಕುಮಾರ್ ಸರ್ ಇಲ್ಲಿಂದ ಬಾಂಬೆಗೆ ಹೋಗಿ ದಾವ ಹಾಕೊಂಡ್ಬಿಡೋಣ, ಪ್ರಾಪರ್ಟಿ ಮೈಸೂರಲ್ಲೇ ಇರಲಿ. ನೋ, ಬಾಂಬೆ ಕೋರ್ಟಿಗೆ ನಾವಿಬ್ರು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ ಅಂತ ಅವರಿಗೆ ಅಧಿಕಾರವೇ ಆಗ್ತದೆ, ಜೂರಿಸ್ಟಿಕ್ಷನ್ ಬರೋದಿಲ್ಲ. ಹಾಗೆ ಅವ್ರ ಜೂರಿಸ್ಟಿಕ್ಷನ್ ಇದ್ರೆ ನಾನು ಇವರು ಬೇಡ, ಹ್ಯಾಂಡ್ಸಮ್ ಆಗಿಲ್ಲ ಜಡ್ಜು, ಮಗ ಖಾವಾಗಿದೆ, ಈ ಜಡ್ಜ್ ಬೇಡ ಆ ಜಡ್ಜ್ ಕೋರ್ಟ್ಗೆ ಹೋಗೋಣ ಅಂತ. ಕ್ಯಾನ್ ವಿ ಸೆಲೆಕ್ಟ್? No, that is the restriction we have in CPC. But under Arbitration Act, again I say, under Arbitration Act, under in the form of section 20, an option is given to the parties. Pardon? Seat of arbitration. Thank you, madam. Seat of arbitration is select. That's the advantage. And in the same fashion, under regular civil code, what happens? Suppose if the property is situated in Mysuru, so we have, no matter we like or don't like, we have to submit ourselves to the jurisdiction of the court. A judge janana, ಅಥವಾ ನನಗೆ ತೆಗೆದುಕೊಂಡಾನ, ಪರಮಾತ್ಮನ ಗೊತ್ತು ಹೋಗೋದು ನಿಲ್ಲಲ್ಲ. Let us try our luck there. ಅದಕ್ಕೆ ನಮ್ಮ ಸೀನಿಯರ್ ಯಾವಾಗಲೂ ಹೇಳೋರು. Of course, even today he says, ಒಳ್ಳೆ ಕೇಸನ್ನ ಕೆಟ್ಟ ಜಡ್ಜ್ ಮುಂದೆ ನಡೆಸಬಾರ್ದು, ಹಾಗೆ ಕೆಟ್ಟ ಕೇಸನ್ನ ಒಳ್ಳೆ ಜಡ್ಜ್ ಮುಂದೆ ನಡೆಸಬಾರ್ದು ಅನ್ನೋದು. ನಾವು ಈ ಒಳ್ಳೆ ಕಥೆ ಆಯ್ತಲ್ಲ, ಇದು ಅಂತ ನಾನು ತಿಳ್ಕೊಳ್ಳೋದು ಏನು ಅಂದರೆ, ಅದಕ್ಕೆ ಅವ್ರು ಏನು ಹೇಳೋರು, ವಿ ಶುಡ್ ನಾಟ್ ಕಂಡಕ್ಟ್ ಎ ಮೆರಿಟೋರಿಯಸ್ ಮ್ಯಾಟರ್ ಬಿಫೋರ್ ಎ ಜಡ್ಜ್ ಹೂ ಡಸ್ ನಾಟ್ ನೋ ರೂಡಿಮೆಂಟ್ಸ್ ಆಫ್ ಲಾ. ಏನೇನೋ ಆಗಿ ಆಯಿತು, ಏನೋ ಅದೃಷ್ಟ, ಅದಕ್ಕೆ ಬಸವಣ್ಣವರು ಕಡೆ ಹೇಳ್ತಾರೆ, ಈ ನುಡಿದರೆ ಹೊರಡು ಹಸನುವುದಯ್ಯ, ಈ ನುಡಿದರೆ ಹೊರಡು ಕೊನರುವುದಯ್ಯ ಅಂತ ಹೇಳ್ತಾರೆ. ಈ ನುಡಿದರೆ ಹೊರಡು ಕೊನರುವುದಯ್ಯ. ಹೊರಡು ಅಂದ್ರೆ ಏನ್ ಹೇಳಿ, ಏನಪ್ಪ ಬಯಲು ಹಸನುವುದಯ್ಯ ಅಂತ ಹೇಳ್ತಾರೆ. Can I say any of you, ಈ ನುಡಿದರೆ, if we get the sympathy and empathy of God, a barren land can be cultivated and it could be easily converted as fertile land. That is the meaning. In the same fashion, ನೀನು ಉಳಿದರೆ ಕೊರಡು ಕೊನರುವುದೆಯ ಒನಕೆ, ಒನಕೆಯಲ್ಲಿ ಯಾರು ಹೊಡೆದಿಲ್ಲ, ಅಜ್ಜಿಗೆ ನಾವು ಅಪ್ಪ ಹೊಡೆದಿದ್ದಾರಪ್ಪ, ಅದಕ್ಕೆಲ್ಲ ನೆನಪಿದೆ, ಸರಿನಾ? ನೀನು ಉಳಿದರೆ ಕೊರಡು ಕೊನರುವುದೆಯ, ಡೆಡ್ ವುಡ್ ಸ್ಟಾರ್ಟ್ ಏನಂತಾರೆ, yielding fruits. For that, what is necessary? God's grace. is the most important for man. Otherwise, of course, somebody says miracles do not happen, but I say miracles do happen. Do happen because an ordinary person like me, who was born in a lowest middle class family, coming and giving lecture in CMR University itself is a miracle. Therefore, miracles do happen. Okay, let's come back. So, as a practical notice, because of compulsion, under normal litigation, ordinary litigation, we must submit ourselves to the jurisdiction of the court. But here, an option is given to the parties. The parties can select their judge. It's a dispute between Mr. A and Mr. B. A suggests name of Sri Ravi Kumar sir. B ಹೇಳ್ತಾನೆ ಬೇಡ ಬೇಡ ರವಿ ಕುಮಾರ್ ಅವ್ರ ಬೇಡ ಬ್ರುಂಗೇಶ್ ಬೇಕು ಅಂತ. ಮಿಸ್ಟರ್ ಎ ಹೇಳ್ತಾನೆ ಬ್ರುಂಗೇಶ್ ಅಪ್ಪ ಬೇಡ ಅಂತ ಅವನಂತ. There is no consensus adult between the parties. Then what is the course? So then a third party, unbiased person. Of course, I am also unbiased and my brother is also unbiased. Somehow, the party does not repose confidence in Mr. Ravi Kumar. In the same fashion, one of the parties does not repose confidence in me. But is this facility available to a party when they go to regular court? No, it is not possible. Of course, I don't say it is not at all. It is totally prohibited. Let me not section 24 of CPC and section 401 of CRPC do bestow such a power to the principal district judge and the high court. Let us not discuss those things. But anyway, under normal scenario, the party will not be having any option of selecting his judge. But such a concept is recognized. Such a concept is recognized under the Arbitration Act. ಸರಿನಾ? ಇವಾಗ ನಮ್ಮಲ್ಲಿ ಆಗುತ್ತೆ ಬೇಕಾದಷ್ಟು ಆಗುತ್ತೆ. ನಮ್ಮಲ್ಲಿ ಒಂದು ಆಗಲೇ ಹೇಳಿದಾಗ ನಮ್ಮ ಸೆಂಟ್ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಏನಿದೆ, normally we get three pattern of matters. First one is CMP, civil miscellaneous petitions. So normally the parties will file a petition before the High Court, and one party dispute that there is no arbitration agreement at all. Other party asserts that there is arbitration agreement, and finally, after hearing the parties, the High Court will decide. The High Court will decide that yes, the matter is to be arbitrated. There is arbitral material is agreement is available. Therefore, it is to be arbitrated. We appoint so and so. We appoint so and so judge. Don't be under the impression that a person to be nominated as arbitrator must be a judge. No. If you have that impression, please remove that impression right now. Right now. Suppose, let's assume, the contractor says that I have used quality material for constructing this building. A mixture, while they prepare the concrete mixture, ಇಷ್ಟು ಮಣ್ಣಿಗೆ ಮರಳಿಗೆ ಇಷ್ಟು ಸಿಮೆಂಟ್ ಹಾಕ್ತದೆ. This is the formula. Of course, as a lawyer, I and you cannot determine. Only an engineer. That too, ಏನು ಸರ್?
Civil engineer.
Thank you, brother. Civil engineer can decide. ಅಲ್ವಾ? ಒಬ್ಬ ಕಂಪ್ಯೂಟರ್ ಅಸಿಸ್ಟೆಂಟ್ ತಗೊಂಡು ಬಿಲ್ಡಿಂಗ್ ಇಂಜಿನಿಯರ್ ನಾವೇನ್ ಮಾಡ್ತಾನೆ, ಇಟ್ ಲುಕ್ಸ್ ನೈಸ್ ಅಂತಾನೆ ಅಲ್ವಾ, ಎಕ್ಸೆಪ್ಟ್ ದಟ್ ಹಿ ಕಾಂಟ್ ಸೇ ಎನಿಥಿಂಗ್ ಅಂಡ್ ಬೀಯಿಂಗ್ ಎ ಜಡ್ಜ್ ಐ ಆಮ್ ಆಲ್ಸೋ ಅನೇಬಲ್ ಟು ಡಿಸೈಡ್ ದಿ ಕ್ವಾಲಿಟಿ ಆರ್ ಅದರ್ವೈಸ್ ದಿ ಕರೆಕ್ಟ್ನೆಸ್ ಆಫ್ ದಿಸ್ quality or otherwise I cannot decide. So then only a civil engineer is the competent person. Under those circumstances, let's assume in an arbitration matter, the question involved is to determine the quality of this building. Then instead of going for a lawyer or a judicial officer, the parties voluntarily can appoint a civil engineer as the arbitrator. that advantage is given to him. Sarina? So it is party friendly. ಹಾಗೆ ಕಂಪ್ಯೂಟರ್ಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಏನೋ ತಾಪತ್ರಯ ಬಂದ್ಬಿಡುತ್ತೆ. An ordinary person like me cannot decide that concept or that ಏನಂತಾರೆ conflict. Under those circumstances, the parties out of their own volition can go for an expert to be appointed as arbitrator. It is for this. Suppose if the parties think that, let us have a retired judge as an arbitrator, and let us request the judge to take the assistance of an expert. Got it? And of course, this concept is available even in Civil Procedure Code also. Article 26 of CPC, I repeat, Article 26 of Code of Civil Procedure does provide for appointment of an expert, of a person to assist the court. Why assistance is required? Because howsoever wonderful my knowledge may be, howsoever wonderful or good my knowledge may be, sometimes I may require some assistance by an expert. When complicated questions with reference to this building or technical issues are involved, then the judge is at liberty to take the assistance of an expert. That is provided in Article 26 rules, Rule 9 and other things, and other rules of Civil Procedure Code, and the same concept is available even in arbitration also. Okay, it's not new, but it is one of the main concepts available in Arbitration Act. And next one is language. This is hallmark of this enactment. I say this is one of the hallmarks of this enactment, because under normal circumstances, the language of the court is in Karnataka either Kannada or English. As far as Honorable High Court is concerned, the court language is English. But as far as trial courts are concerned, yes, only two languages are considered as court languages, either Kannada or English. So now, Section 22 of the Arbitration Act does bestow a liberty to the parties, to have these arbitral proceedings in a language different from Kannada or English. Let's assume, of course, an instance had taken place when I was the officer of 16th ACMM, both from Thank you, sir. Thank you very much. Because my memory is, because of it, my memory is getting deteriorated. Kanipakam Hatra, Ibru, both came from such a remote village near Kanipakam, and both had come to Bengaluru, and each invested 1.2 crores, 1.2 crores. Their intention was to purchase some agriculture properties, then get that converted in from agriculture purpose into non-agriculture purpose, and farm a layout and sell and make money. Of course, this was the intention of the parties. Initially, initially everything was good. Afterwards, the differences began, and they become wider and wider, and denser and denser by passage of time. And ultimately, one day they sat together and decided not to continue that project. They wanted to give up. Okay, they gave up. But a person, to clear off this, adjustments, he gave a check for rupees 80 lakhs. One person gave a check for rupees 80 lakhs. When the check was presented for encashment, it was bounced because of the insufficiency of funds in the account of the other matter. So he compared all the provisions like clause A, clause B, clause C of section proviso appended to section 138 of the MI and finally find the compact. Do you know the interesting part is this? ಇದು ಸುಮಾ ಟ್ರೈಲರ್ ಅಂತಲ್ಲ ರಜನಿಕಾಂತ್ ಹಾಗೆ ಇಷ್ಟೊತ್ತು ಹೇಳಿದ್ದು ಸುಮಾ ಟ್ರೈಲರ್ ಇದು ನಿಜವಾದ ಸಿನಿಮಾ ಈಗ ಏನ್ ನಿಜವಾದ ಸಿನಿಮಾ ಅವರಿಬ್ರಿಗೂ ಪಾಪಿಗಳು ಇಬ್ಬರಿಗೂ 6 ಟೋನ್ ಕನ್ನಡದಲ್ಲಿ ಬರಲ್ಲ the mother tongue of both the component and accused was Telugu. ನಾವು ನನಗೂ ತೆಲುಗು ಸುಮಾರಾಗಿ ಬರುತ್ತೆ ಫ್ರೆಂಡ್ಸ್ ಜೊತೆ ತೆಲುಗು ಮಾತಾಡೋದು ಫ್ರೆಂಡ್ಸ್ ಜೊತೆ ಹಿಂದಿ ಮಾತಾಡೋದು ಇಟ್ಸ್ ಟೋಟಲಿ ಡಿಫರೆಂಟ್ ಫ್ರಮ್ ಕಂಡಕ್ಟಿಂಗ್ ಎ ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಸಿಟಿಂಗ್ ಆನ್ ದ ಡಯಾಸ್ ಅಲ್ವಾ ಈಗ ಇಲ್ಲಿ ರಾ ಅನ್ನೋ ಒಂದು ಕೋರ ಅಂದ್ರೆ ಏನಾಗಲ್ಲ ಅವನು ಅಟ್ಲುಗಾರ ಅಂತ ಹಿಂಗೆ ಕೆಟ್ಟ ಏನೋ ಹಿಂಗೆ ಹೇಗೆ ಹೇಳಬೇಕು ಅಂದ್ರೆ ಈ ಕರೆಕ್ಟ್ ಮೀ ಅದು ಪೂರ ಅನ್ಬಾರ್ದು ಕಣೋ ರಾ ರಾ ಅವಾಗ ರಾರ ಅಂದ್ರೆ ಅದೇ ಓಕೆ ಸೊ as I brought to your notice, speaking in a different language with our friends is totally different from conducting court proceedings by using different language. It is different. Then I did not have the courage to conduct the proceedings in Telugu. I took the assistance of a lawyer who knew both Kannada and Telugu. Okay. So now, here, if the parties wish in arbitration, this is the wonderful part of this legislation is, if the parties wish, they can opt for a judge to be a person to be nominated as an arbitrator who knows Telugu, and they may request that arbitrator to conduct the entire proceedings in Telugu. Everything is permissible under section 22 of the arbitration. This is the wonderful part. Okay. Just 2 minutes before I brought to your notice that one person files civil miscellaneous petition. I repeat, one of the parties to that agreement files a civil miscellaneous petition before the Honorable High Court of Karnataka, requesting that this is the agreement we have entered into, and so now my counterpart is not willing to adhere to his part of the contract. He is not ready to perform his part of the contract. He is going back. He is withdrawing himself. So therefore, ask him to perform his part of the contract. So this is the suit I am intending to fight. This is the suit I am intending to fight. But I don't have the patience to approach the regular court because it's time consuming. So therefore, and moreover, in the agreement itself, there is a clause which provides for appointment of arbitration. ಸಾಮಾನ್ಯವಾಗಿ ಬರ್ದಿರ್ತಾರೆ ಕನ್ನಡದಲ್ಲಿ ಬರೆಯೋದಾದ್ರೆ ಆರ್ಬಿಟ್ರೇಷನ್ ಸೆಂಟರ್ಗೆ ಹೋಗೋದು ನಮ್ಮಿಬ್ಬರ ನಡುವೆ ಭಿನ್ನಾಭಿಪ್ರಾಯಗಳು ಬಂದ ಪಕ್ಷದಲ್ಲಿ ಆರ್ಬಿಟ್ರೇಟರ್ ಮೂಲಕ ಬಗೆಹರಿಸಿಕೊಳ್ಳುವುದು ಅಂತ ಬರ್ದಿರ್ತಾರೆ. Suppose if it is in English vernacular, English language, then it would be recited that in case of any conflict, the same should be resolved by an arbitrator. So this is the normal clause that would be incorporated in an agreement. That would be incorporated in an agreement. So one of the parties will do is this. He highlights that portion or the condition part of the Honorable High Court of Karnataka, and in turn the High Court will go through that passage of paragraph, whatever it is, and finally decides and appoints one arbitrator. This is what I brought to your notice. Now the question is this. Now we are too intelligent. We Indians are too intelligent, too individuals. In what? In cheating. I am sorry to pass these remarks because after completing 26 long years as a judge and before that 7 years as a lawyer, it's my humble opinion, honest opinion, and if somebody opposes, I don't go back. This is my firm stand. ಯಾರು ಅದು ಯಾವ್ದು ಸಿನಿಮಾ ಅದು ಪುನೀತ್ ಅದರೊಂದು ಹಾಡಿದ್ದಾರೆ ಯಾವುದು ಎಂದ ಹಾಳಾಗೋಗ್ಲಿ ನಾವು ಕಾಸು ಮಾಡೋಣ ಅಂತ ಯಾವುದು ಸಿನಿಮಾ ಯಾರಪ್ಪ ಕರೆಕ್ಟ್ ಮಾಯಾಬಜಾರ್ ಅದ್ಭುತವಾದ ಸಾಂಗ್ ಅದು ಅಲ್ವಾ ಕರೆಕ್ಟ್ ಅದ್ಭುತವಾಗಿ ಡಾನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ ಒಂದು ಸಾಲು ಬರುತ್ತೆ ಯಾವುದು ಎಂಗಾನ ಹಾಳಾಗೋಗ್ಲಿ ನಾವು ಕಾಸು ಮಾಡೋಣ ಅಂತ ಎಸ್ ಪಿ ಬಾಲಸುಬ್ರಹ್ಮಣ್ಯಂ ಅವರು ಹಾಡಿದ್ರು. Now the present mindset is this: ಯಾರ ಸಾಯಿ, ಯಾರ ಉದ್ಧಾರ, ಯಾರ ಕಾಡಿಗೋ, ಯಾರ ನಾಡಿಗೋ, ಯಾರಿಗೆ ಕುಟ್ಟೋ, ನಾವು ಕಾಸು. ಸೊ ದಿಸ್ ದಟ್ ಸೊ ಏನ್ ಮಾಡ್ತಾನೆ? ಸೊ ಇದೆಲ್ಲ ನೆನ್ಪಿಟ್ಕೊಂಡು ಅರೆ ಮಾಯಾಬಜಾರ್ ನೆನ್ಪಿಟ್ಕೊಂಡು ಉಳಿದಿದ್ದೆಲ್ಲ ಮಾಡಿ that is not the intention. You forget Mayabazar and remember whatever other discussions we made. So why I brought this? Let's assume a CNP petition is filed. It is pending adjudication before the court. I mean, be it before the Supreme High Court or Supreme Court, whatever it is. Within 1 or 2 days, the matter will not be decided. It will take, if not more, at least a fortnight's time, 15 ದಿನ ಬೇಕು ಅಲ್ವಾ ಸರ್? ಜಾಸ್ತಿನೇ ಬೇಕು. Okay, let's assume 15 days ಬೇಕು ಅಂತ. So now within that 14 days or 15 days time, during that interim term, one of the parties who is in advantageous position, he makes an attempt to sell the property. In ಮಾರಕ್ಕೆ ಒಂದು 15 ದಿನ ಬೇಕಾ? No, 1 day is sufficient. So he will sell the property, take the sale profits and price away. So then what is the remedy? ಅಲ್ವಾ? ಕಾಸು ಹೋಯ್ತು, ಕಾಸು ಕೊಡು ತಲೆಯು ಕೊಡು ಅಂತಾರೆ ನಮ್ಮೂರ ಕಡೆ. ನಮ್ಮ ಮೈಸೂರು ಕಡೆ ಇಟ್ಸ್ ಫೇಮಸ್ ಆಡ್ ಕಾಸು ಕೊಡು ತಲೆಯು ಕೊಡು ಆಯ್ತಲ್ವಾ? So when the CMP is pending adjudication before the High Court, one of the parties who is in advantageous position, he sells the property and takes the sale consideration and flees away from the spot. Then immediately after selling the property, his whereabouts will become unknown to everybody. Even if you approach his parents or family members, they would say, "Amuk gottilla, ellu gottna, one vaara aaytu manage bandu" anತಾರೆ. This is the scenario we get to see everywhere. What is the remedy there? Is there any way which does provide for filing petition till the decision on CMP petition? ಅಲ್ವಾ? CMP ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ತೀರ್ಮಾನ ಆಗುವವರೆಗೆ ನಮಗೇನಾದ್ರೂ ಒಂದು ಪರಿಹಾರ ಕೊಡ್ರಿ ಅಂತ ಬೇಕಲ್ಲ. ಮತ್ತೇನು ಬೇಡ, restrain that person from selling the property, from creating some encumbrance. Please restrain that person from creating any encumbrance in respect of this property. If you don't restrain him, he would sell, he would alienate the property, he would create some encumbrance, then I will not get my money back. My entire life will be ruined. Such a plea is put forward before the High Court. But unfortunately, while hearing the CMP matter, the High Court cannot entertain such an application. Therefore, a remedy is provided in the form of Section 9 of this Arbitration Act. What does it say? What does it say? It does say that when the civil miscellaneous petition is pending adjudication before the High Court, the party is at liberty to file a regular petition and suit before the court and seek for interim order, ಮಧ್ಯಂತರ ಆದೇಶವನ್ನ ಮಾಡಿ ಅಂತ ಕೇಳ್ಬೋದು. What is that interim order? Interim order only to preserve the property, only to preserve or protect the property till that is decided, till that case is decided, which is pending adjudication before the High Court. Please stop him, restrict this so and so my counterpart from selling or creating any sort of encumbrance in respect of this property. This is the relief he can seek before the regular court That is provided in section 9. And a situation may also crop up for consideration when the initial period of this arbitration process. Because normally what we do, even Act and our rules provide that 6 months time is earmarked for completion of pleadings. You all know what pleadings is, claim and written statement. So in arbitration we call it as claim petition and written response. But claim petition is nothing but replica is nothing but claim and written what I said response. Response is nothing but written statement. So this law itself provides for 6 months for completion of these pleadings. Yes, Mr. Ravi Kumar is appointed as arbitrator, and let's assume only 1 month has elapsed after his appointment. Only 1 month has elapsed, and still the parties have not filed or completed the pleadings. In this period, the person who is in advantageous position makes an effort to do some unwanted thing in respect of the property because he wants to cheat his counterpart. Output attack. Sarina, ಏನು ಮಾಡೋದು ಈಗ? For that also section 9 provides, because that's how the opening word of section 9 says that during, after, and before, during, and after the arbitral process. That's how it commences. ರವಿಕುಮಾರ್ ಸರ್ನ ಆರ್ಬಿಟ್ರೇಟರ್ ಅಂತ ಮಾಡೋದಕ್ಕಿಂತ ಮೊದಲು ಮಾಡಿ ಅವರು ಚಾರ್ಜ್ ತಗೋತಾರಲ್ಲಪ್ಪ ಅಲ್ಲಿವರೆಗೆ ಮತ್ತು ಅವ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದ್ಬಿಡ್ತಾರೆ, ಅವಾರ್ಡ್ ಮಾಡ್ತಾರೆ. ಅವಾರ್ಡ್ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ ನಾನು ಅದನ್ನು ಡಿಗ್ರಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡೋವರೆಗೆ ಟೈಮ್ ಇರುತ್ತಲ್ಲ, ಆ ಟೈಮಲ್ಲಿ ಮತ್ತೆ ಟೋಪಿ ಗಿರಾಕಿ, ನಾನು ಟೋಪಿ ಹಾಕಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. Then what is the remedy? That's why if I read section 9, then it would be advantageous for each one of us. Interim measures by court. A party may, before or during arbitral proceeding or at any time after the making of the arbitral award, but before it is enforced in accordance with section 36, apply to a court. So therefore, by incorporating section 9 or by designing in such a way the section 9, the legislators made all the could foresee all the possible disastrous actions that could be invented by a mischievous party. I repeat, they could foresee all the possible mischievous actions that could be resorted to by one of the parties, that is section 9. So now the question is this, another concept, important concept. Yenadu, in the light of section 20, I brought to your notice that the parties are at liberty to select their judge, select the place of suing, and select the language as per section 22. ಭಾಷೆಯನ್ನ ಆಯ್ಕೆ ಮಾಡ್ಕೋಬಹುದು, ನಮ್ಮ ಜಡ್ಜ್ ಸಾಹೇಬರು ಯಾರಾಗಬೇಕು ಆಯ್ಕೆ ಮಾಡ್ಕೋಬಹುದು, ಯಾವ ಸ್ಥಳದಲ್ಲಿ ಪ್ರಕರಣ ನಡೆಯಬೇಕು ಅದನ್ನು ಆಯ್ಕೆ ಮಾಡಬಹುದು. ಆಲ್ ದ 3 are given to his discretionary power. They can select. Now the question is this, ಈಗ arbitral tribunal ನೀವು ಹಾಕಿದ್ದೀರಿ, before the decision passed in CLP, either this way or that way, the party who is in advantageous position makes an effort to sell the property. So that's what I say. I brought to your notice in the form in the light of section 9. The party who is aggrieved, who is not happy with these proceedings, can approach the court. So now the question is, can the parties approach court of their choice? ಹೇಗೆ ಪ್ರಾಪರ್ಟಿ ಮೈಸೂರಲ್ಲಿ ಇದ್ರೂ ಬೆಂಗಳೂರಲ್ಲಿ ಆರ್ಬಿಟ್ರೇಷನ್ ಟ್ರಿಬ್ಯುನಲ್ ನಡ್ಕೋಬಹುದು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಹಾಗೆ ಮೈಸೂರು ಕೋರ್ಟ್ ಬೇಡ, ಬೆಂಗಳೂರಲ್ಲಿರೋ ಕೋರ್ಟ್ ಅಲ್ಲಿ ದಾವ ಹಾಕ್ತೀನಿ ಅಂತ ಸೆಲೆಕ್ಟ್ ಮಾಡಬಹುದಾ? ದಿಸ್ ಇಸ್ ದ ಕ್ವೆಶ್ಚನ್. But the answer is big no. Am I boring? Am I ಏನಂತಾರೆ ಏನಪ್ಪ ನಮ್ಮದು ಕನ್ನಡ ಮಾಧ್ಯಮ ಒಟ್ಟಕ್ಕೆ ಬರಲ್ಲ ಕೆಲವು ಪದಗಳು. ಹೋಗ್ಲಿ, ಆಸಕ್ತಿದಾಯಕವಾಗಿದೆಯಾ ಅಥವಾ ಬೋರ್ ಆಗ್ತಾ ಇದೆಯಾ? Somebody is yanning, my friend, I request my brother who is yanning to reply. Yes, ಅಲ್ಲಿ ಸಿಂಹಾಸನದ ಮೇಲೆ ಕೂತಿದ್ದಾರಲ್ಲ ಹೌದು. Sir, don't forget that I am also a last bench student. I was so mischievous. I played all these tricks, I played all humorous things, all cunning things, and now I am a judge. I have done everything which you could treat it as nonsense. Don't think that I don't know anything. I have passed through all these stages, including the student stage, and I was a very mischievous guy. Unfortunately, today I am receiving it. That's the problem. Alva? Okay, yes. Pardon? Okay, when you become lawyer, you realize the importance of a judge. No question of yanning, no question of whispering, nothing. You must be vigilant always. Otherwise, we know how to handle the situation. ಏನಿಲ್ಲ, ಒಂದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೊಡದೆ ಸಂಜೆವರೆಗೆ ಸತಾಯಿಸ್ಬಿಟ್ರೆ ಸಾಕು. Even if you ask 100 times, 1000 times, I pray my Lord, I pray my Lord, I pray my Lord. If you don't give the date, that is the biggest punishment for a lawyer. We know, always, sir? Yes. Okay, let me come back. Let me come back to this. Now, ಅಂತಹ ಸಂದರ್ಭಗಳಲ್ಲಿ ಅಂದ್ರೆ when the petition CMP is pending adjudication, and if somebody does something which is not warranted in the facts and circumstances of the situation, then the court has got the jurisdiction. Intelligently or importantly, the English grammar also assumes significance here. We always speak about articles A and B. A and B. They, with their eyes wide open, the legislators have prefixed the word court with th in the. Therefore, they speak about a definite court. Every court cannot become court. A particular court should be approached. That is the mandate of law. What is the court? If we see the section 2, then it becomes very clear that it is nothing but embracing the old concept what we had been following. Of course, what we have been following even today in the light of section 15, 16, 17, 18, 19 and 20 of Code of Civil Procedure. To put it differently, if the property is situated in Mysore, though parties will opt for an arbitral tribunal to be conducted in Bengaluru, for the relief under section 9, they must approach the Mysore court only. I hope I made the position I made myself very clear. Though the parties opt for a neutral place or faraway place as the arbitral tribunal, okay, but for the reliefs under section 9, they must approach the court within whose jurisdiction the property is situated. That is the mandate of law. That's why, with their eyes wide open, the legislators have employed the word, prefixed the word "the" before that word "court." Therefore, the court means, for the purpose of section 9, it is the court within whose jurisdiction the property is situated. Therefore, if somebody argues that yes, any court in the state or in the country could be approached even for the purpose of obtaining some relief from section 9? No, they are totally wrong, and that concept is misconceived. And next one is important concept or proceeding is enshrined in the form of section 17 of Arbitration and Conciliation. Hitherto, I have been highlighting the situations that would crop up for consideration before the commencement of the arbitral proceedings. As I brought to your notice, my brother Sri Ravi Kumar is appointed, let's assume, he is appointed as an arbitrator. He took charge about 3 months before. Today, the readings are completed. Tomorrow, I entrust the entire file to Sri Ravi Kumar sir. Being the director of Bengaluru Arbitration and Conciliation Center, I entrust or hand over the entire file along with documents, whatever is supplied or furnished by both the parties, to Sri Ravi Kumar sir. Immediately, Ravi Kumar sir becomes the court for all practical purposes. I mean, what are the rights that could have been exercised by a regular court in the form of section 9 could all be exercised by Sri Ravi Kumar as the officer or the arbitrator officiating in the arbitral tribunal. ಅರ್ಥ ಆಯ್ತಾ? ಈ ಕಡೆ ಹೇಳಿ. Yes. ಅರ್ಥ ಆಯ್ತಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ ಹೇಳಿ, ಇಲ್ಲ ಅಂತಾನೆ ಹೇಳಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. Let me have the opportunity of introspecting. Let me introspect and come back. Okay, section 70, that is section 70. And the next important concept is incorporated in the form of section 19, rules of procedure. So when we approach regular civil court, I and you have no option. If it is civil proceedings, we have to adhere to code of civil procedure. If it is criminal matter, we have to adhere to criminal procedure code. We have to follow meticulously. I and you have no choice at all. Meticulously, we have to follow all the rules and the procedures. In case of documentary evidence, I and you and any judge for that matter has to meticulously follow the rules and the regulations incorporated in Evidence Act, Indian Evidence Act. I cannot bypass or I cannot overlook a procedure. That is the mandate of law. But section 19 of Arbitration Act does bestow a power to the arbitrator to select his own procedure. The parties at the inception of the proceedings itself, they may say, "Bada sir, ಅಷ್ಟೊಂದು ಸ್ಟ್ರಿಕ್ಟ್ ಆಗಿ ರೂಲ್ಸ್ ಆಫ್ ಎವಿಡೆನ್ಸ್, ರೂಲ್ಸ್ ಆಫ್ ಪ್ರೊಸೀಜರ್ ಏನು ಹೇಳಿ ಅಲ್ಲಿ ಇಲ್ಲಿ ಸ್ವಲ್ಪ ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಕೊಡ್ರಿ ಅಂತ ಹೇಳುವ ಸ್ವಾತಂತ್ರ್ಯ ಪಕ್ಷಕಾರರಿಗೆ ಆ ಸ್ವಾತಂತ್ರ್ಯ ಇದೆ. But such liberty or concession is hard to see in a regular criminal litigation or civil litigation. Hard to see. We cannot say. So that is the option or the one of the finest concept or let us say new trend incorporated to this Arbitration Act. Next concept is incorporated in the form of section 29A, 29B fast track procedure. Fast track procedure. Of course, it is not new. Old wine in a new world. Had it been vice versa, probably it would have been a wonderful thing. Martin, the arbitrator concern can pass judgment only on the basis of the admitted document. I don't say it is new because Order 12 Rule 6 CPC does bestow power to a normal civil court that pass judgment on admitted admissions. It is not new. But here, so many things are there. A document is present. Let me give one example here. I was the officer of what? Did you say anything? No. Okay, are you hearing me? No. Fine. I was the officer of Krishnarajapete Court, not Krishnarajapuram, Krishnarajapete in Mandya district. For 4 years, from 2004 to 2008. Then I was the junior division officer. One document, Shaley, was pressed into service. ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಎಲ್ಲರದ್ದು ಮಾತೃಭಾಷೆ ಕನ್ನಡನೇನಾ ಅಥವಾ ಬೇರೆ ಯಾರು ಇದ್ದೀರಾ? ಎಲ್ಲರದ್ದು ಕನ್ನಡ. ಕನ್ನಡದವರು ಯಾರು ಹೇಳಿದ್ದಾರೆ? ಅಲ್ವಾ, ನಾವೇ ಸ್ಟ್ರಾಂಗ್. ಗುಡ್. ಇವಾಗ ಪ್ರಾಕ್ಟೀಸ್ ಬಂದಿದ್ದವರು ಅಲ್ಲಿ ಒಟ್ಟು ಬಿಟ್ಟು ಅಂತ ಇದೆ. ಒಟ್ಟು ಬಿಟ್ಟು ಇವಾಗ ಓ ಓ ಔ ಬರುತ್ತಲ್ವಾ? ಓ ಒಟ್ಟು ಬಿಟ್ಟು ಅಂದ್ರೆ ಹೀಗೆ ಬರುತ್ತೆ ಅಲ್ವಾ? ಅಲ್ಲೇನಾಗಿತ್ತು? It's very interesting. It's very interesting. If you listen to me carefully, then only you can follow. Otherwise, either you become laughing stock or I become laughing stock. That's the only result. ಅಲ್ಲೇನಾಗಿತ್ತು? 8 ಅಥವಾ 9 ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಆಸ್ತಿಗಳನ್ನು ಮಾರಿದ್ರು. ಡಿಫರೆಂಟ್ ಎಕ್ಸ್ಟೆಂಟ್. ಒಟ್ಟು ಬಿಟ್ಟು there were 8 or 9 small extent of property situated in different survey numbers were sold by Mr. A to Mr. B. ಒಟ್ಟು ಅಂತ ತಗೊಂಡ್ರೆ it includes everything. ಬಿಟ್ಟು ಅಂದ್ರೆ it excludes this one. ಅದು ಅಲ್ಲಿ ಬರೆದಿರೋದು ಒಟ್ಟು ಅಂತಾನ ಬಿಟ್ಟು ಅಂತಾನ. That's the only dispute between the parties. But in the document, the scribe of that document was so intelligent. The moment we see the word "vattu," if you look at it from this angle, it looks like "vattu." If you slightly turn this one, it looks like "bittu." ಮ್ಯಾಲ ಒಂಥರ ಕಾಣಿಸೋದು, ಕೆಳಗೆ ಒಂಥರ ಕಾಣಿಸೋದು, ಒಳ್ಳೆ ಗ್ರಹಚಾರ ಆಯ್ತಲ್ಲ. ಏನ್ ಮಾಡೋದು? ಸಿ ಆ ಕೇಸಲ್ಲಿ ಅದು ಬಂದು ಬಿಟ್ರೆ ಎವ್ರಿಥಿಂಗ್ ವಾಸ್ ಅಡ್ಮಿಟೆಡ್. The parties were at variance only about that word. If it is to be construed as vattu, then my conclusion would be something else. If I were to conclude that it is bittu, my conclusion was to be something else. So everything was admitted. When such admitted positions are available, then the court can conveniently pass judgment without recording the oral evidence. Without recording the oral evidence. Let's assume, day before yesterday I was hearing a matter. Then I concluded, if we add all the extent, could it fit to the word vattu? Or could it fit to the word vittu? In such a way, because, okay, I did stop abruptly, sorry. In the original document which was pressed into service or produced before me, it was not clearly visible. It was difficult to conclude that was it vattu or was it vittu. Then I went one step further and summoned the sub-register officer to produce the original register itself. The person who copied. Do you know that procedure? Any document is presented for registration. After registration, whatever the contents available in the document will be copied to a register maintained in the sub-register. This is the rule. As per rule 22 or 23 of Registration Act. So while copying, even the copier did not take any discussion. ಅವನು ಶ್ರಮ ತಗೊಳ್ಳಿಲ್ಲ ಇದು ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಯಾಕೆ ಬೇಕು ಗ್ರಹಚಾರ ಅನ್ನೋ ತರ ಅಲ್ಲಿ ಒರಿಜಿನಲ್ ಪೇಪರ್ ಹೆಂಗಿತ್ತು ಅದೇ ಸ್ಟೈಲ್ ಬರೆದು ಬಿಟ್ಬಿಟ್ಟಾವ. So even after summoning the original document, it did not help me at all. So then I invented an indigenous method. This indigenous method cannot be provided by artificial intelligence. Only human being can do it. That's why human beings are always good. But unfortunately we are largely depending upon artificial intelligence. Then it could be an example of Endiran. ಇದು ಅವನೇನು ಮಾಡಿದ್ದ ಬಡದವನು ಹಿಂಗ್ ತಗೊಂಡು ಇಲ್ಲಿ ತಂದು ನಿಲ್ಲಿಸ್ತಾನೆ. ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಅದು ಇಲ್ಲಿಗೂ it did not match this one or this one. It was that word itself was a unique one. Then what I did was I added all the extents which were intended to be sold by industry A to B, and then I deducted. So then first I added, then what the total extent came, and I verified that it did match with the total extent mentioned in the inception of the document or not. So then I concluded that it will be considered as vattu. ಅದನ್ನ ಬಿಡಿ. ಸೊ ಹಾಗೆ ಒಂದು ದಾಖಲೆಯಲ್ಲಿ ಎಲ್ಲ ಬರೆದಿದ್ದಾರೆ. ಎವ್ರಿಥಿಂಗ್ ಈಸ್ ಅಡ್ಮಿಟೆಡ್. Only one word or one concept is not accepted by parties, but we can't change it. What is written is written, is available in the document. Then if the parties say that we admit this document, and according to me, I interpret this clause in this way. But another man says that no, that is not the proper interpretation. It should be interpreted in this way. If that is the case, then it is left to the arbitrator. He has to read on his own, and to his best of ability and knowledge, he must interpret that clause. What exactly the passage or paragraph does convey. Does it suit the arguments advanced by this man, or does it suit the arguments advanced by his counterpart? That's the only decision. Under those circumstances, no necessity to record the oral evidence, no necessity to ask the witness to enter the witness box, take oath and give evidence. No, we can fast track the proceedings. Of course, I don't say such a facility is not available in CPC. Of course, as I brought you a notice under Order 12, Rule 6 CPC, the facility was always there. Even today it is there, and it is left to the arbitrator. If the parties and the arbitrator do say or do agree that there is no necessity of producing any oral evidence, recording the evidence of any witness. Only the recitals or the terms and conditions incorporated in a document are sufficient to decide the question involved in the case. Then no necessity to record the evidence. ಹಾಗೇನೆ yes, okay. Of course, I have other things to share, but I feel it's enough. You should say enough. Of course, rather I'm saying it's enough. So it will not consume much time. Okay, before parting, once again, I extend my sincere thanks to the Sri Subramaniam sir and his team and other officials of this CMR University for giving me this wonderful opportunity. And my thanks are due to each one of you for giving me this patient hearing. Thank you very much.